Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 18th and case number 19th in the list of leading cases for the AOR examination. The two cases are TMA Pai Foundation and PA Inamdar versus State of Maharashtra. So the full title goes like TMA Pai Foundation versus State of Karnataka and PA Inamdar versus State of Maharashtra. Both are talking about unaided minority institution, and both are coming in a similar timeline. When TMA Pai is being adjudicated in 2002, TMA Pai is adjudicated in 2002, PA Inamdar is coming in 2004. And once we reach the end of the discussion, there is a very interesting turn that the Constitution of India takes. But however, that is the academic discussion we will do after we complete these two cases. Now, what is happening in TMA Pai? Before going into that, we need to understand the two articles. One is article number 29 and another is article number 30. So article number 29 and article number 30, both are talking of minority rights, cultural and linguistic minorities. So Article 29 says that any section of the citizen residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. So it is talking of conservation of linguistic, scriptural, or cultural heritage. And clause 2 is telling you, 29 clause 2 is telling you, no citizen shall be denied admission into any educational institute maintained by state or receiving aid out of state funds on the grounds only of religion, race, caste, language, or any of them. So basically, it is also protecting the interest of minorities, saying that no citizen, this is a citizen-based right. We need to understand it is available only to the citizen of India. So no citizen shall be denied admission into any educational institute. Focus word here is any educational institute maintained by state or receiving aid out of state funds. Maintained by state and receiving aid out of state fund. Another, another phrase that you need to notice in this provision, on the grounds only of religion, race, caste, language, or any of them. Now, this is clear that clause 2 herein is no discrimination clause in any educational institute basis religion, race, caste, language, or any of them. Now, when I come to Article 30, because both of them are talking of minority rights, Article 30, Clause 1, I am going to look at. It is saying, we refer to this clause once when we were doing AMU case, AMU versus Naresh Agarwal in the previous judgment, we discussed. So now, all minorities, whether based on language or religion, shall have the right to establish and administer educational institute of their choice. So this is giving the right to minorities to administer, to establish the institute of their own choice. Now the word here is administer educational institution of their own choice. Okay, so they can establish an institution and they can also administer, they can also manage it on their own volition. Now, when I am looking at Article 30, Clause 1, and I am looking at Article 29, Clause 2, there is a debate that on one side, you are allowing minorities to have their institutes, their linguistic minority or religious minority institutes established, and they can also administer them on their own choice. But 29 clause 2, which is also falling in the protection of minority rights, is saying that any educational institute that is maintained by the state fund or it is also receiving aids out of state fund shall not deny admission to anyone on the basis of religion, race, caste, or language, or any of them. So if we look at 29.2 and we look at 30 clause 1, there are two sides of the coin. So which side will supersede another? Which side will prevail? So that debate is discussed in the case of TMA Pai Foundation versus State of Karnataka. The moot question before the Supreme Court here is to adjudicate which provision, whether 29 clause 2 will gain supremacy over 30 clause 1 or whether 30 clause 1 shall gain supremacy over 29 clause 2. The court herein is looking at the question. Okay, so on the screen is TMA Pai Foundation as explained in the judgment. The head notes are there on the website, the GSCR website. Now herein the court is saying that minority communities have the fundamental right to establish and administer their own educational institute of their choice. This is a right given to them in Article 30, Clause 1. However, you know, however, this right is not absolute, because 29 Clause 2 is also coming and is saying that you can administer your educational institute, but if your educational institute is receiving aid out of state, then it also has to stick to no discrimination policy. Now, what is happening in TMA Pai? So what is happening in TMA Pai? The court is dividing minority educational institutes into two categories. One is the unaided and another is the aided, because the aided one will then come in the purview of Article 29 Clause 2. Because you are a minority institution, we give you the autonomy to establish, we give you the autonomy to administer your institute. But when you are receiving the aid out of state, when you are sponsored by state, and when you are maintained by state, you need to stick to the mandate of state, which is also providing for the reservation, right? Now you have to stick to the clause of Article 29, Clause 2. Okay. Now, when we go ahead, minority educational institute are becoming divisible into two kinds, one being the aided one and another being the unaided one. Okay. So TMA Pai is saying that aided will be subject to 29 Clause 2. But when I am talking about unaided, because Article 29 Clause 2 is restrictive in the language. It is saying that educational institute maintained by the state or receiving aid of the state. So when an institute is minority in nature, it is not receiving any grant from the state, it is not receiving any aid from the state, it is not maintained by state. Why would Article 29 Clause 2 govern it? So TMA Pai is basically saying that in the case of unaided institution, and especially unaided minority institution, state will not exercise absolute right over it. So state will let the administration, let the establishing authority, let the board of directors, whatever the institute has, be in their own autonomy to adjudicate the decisions relating to the institution. They can, have their own set of principles, they can have their own set of guidelines. They need not stick to the principle, to the state policy, to Article 15 as well, to Article 29 Clause 2 as well, because they are not receiving the grants from the state. Now, this is also drawing an intersection with Article 19(1)(g), which is the freedom to carry on one's business, one's trade, one's occupation, one's profession, as well as Article 30 Clause 1, which is saying that minority institution to have a right to administer their own institute. Now, both of these liberties are given to unaided minority institution because they are not receiving any kind of state funding to maintain their institute. Okay. Now the courts are herein saying that that government can interfere, the state can interfere, but it will only interfere to the extent that it is issuing guidelines with respect to the quality of education, what kind of education standard, welfare of students. That's only something which the government or the state would be concerned with. Otherwise, the court will not be concerned with uh, how the administration is going on, right? Now, government cannot interfere with the unaided institutes, absolutely. And in case of aided, governmental policies need to be adhered to because they might be the conditions for granting aid. So court herein is also saying that in the case of private aided educational institute, once the aid is granted, government as a condition Yes, government as a condition for granting of aid can put fetters on the freedom in the matter of administration and management of the institute. But such institutes cannot be treated as wholly owned and controlled by the government. So now there are two kinds of institution. One is government, one is private. Governments are completely aided, so they will directly fall under the scrutiny of state. But when I am talking of private, it is unaided and it is aided. So unaided, again, they will fall out of the scrutiny of government. But in the case of aided private, the discretion, the exercise of discretion of the government shall be to the extent that conditions on which the aid is granted has to be maintained. and rest they will not exercise their discretion in the matters governing governing the administration of private aided institutions, right? So here the court is drawing a balance between Article 29 Clause 2 and Article 30 Clause 1, saying that both needs to be harmoniously construed in the case of aided institutions, and therefore Article 29 Clause 2 shall have primacy. The level of interference of state, interference of government in the case of aided minority institution shall be to the extent that Article 29 Clause 2 is adhered with. Okay, so Article 30 Clause 1 cannot be therefore read in isolation. The provision has to be read in the consonance with the mandate guaranteed under Article 29 Clause 2. Now, this was held in the case of TMA Pai Foundation versus State of Karnataka. Now, moving on to the next case. The next case herein is one more thing that TMA Pai is holding, that unaided institutes are not required to have reservations quotas in them, which are there in Article 15, Article 29, Clause 2. They can come up with their own policies to take admission. But however, with respect to fees, the fees should not be such that it amounts to capitation fee, right? It should not be exorbitant in nature. It should not be prima facie profiteering in nature. And the court herein is also saying that the government may have interference with respect to the quality of education delivered. Admissions should be fair, transparent, and merit-based, specifically in the professional courses. That is what the court herein is adjudicating. Now we come to the next case, which is the case of PA Inamdar versus State of Maharashtra. Now, in this case, the debate is more or less similar, because herein the moot question is to what extent state can exercise power in regulation of admission and fee structure, state seat quota, implementing reservation policy, and etc. in a minority institution. Okay, so now here we are adjudicating the legality of state imposed quota. Now, quotas are mainly in discussion in this case, PA Inamdar's case. Okay, so court herein is adjudicating what is the legality of state imposed quotas. State imposed quotas in minority, in private unaided institution mainly. Okay, in private unaided. So the subject here is private unaided. What is the legality of state imposed quotas in private unaided institutions? Whether state has the power to regulate its fees, or whether minority, we are also adjudicating it with respect to Article 30 Clause 1, which is talking about the minority institutions. Now, herein is in this case is held that in unaided institutes, okay, so the institutes which are unaided, which are not working on governmental funding, there is no strict requirement to adhere to the reservation quota. Okay, so no state quota in unaided private institutions. Court is ruling here that state cannot enforce reservation or quota in private unaided professional colleges, whether, now the main point here is whether they are minority or whether they are non-minority. Okay, so whether they are minority or they are non-minority, it does not matter. If the college is private, unaided, then in that case, state imposed quotas cannot be made. Reservation shall be at the discretion of the management of the private unaided quota. So court herein is saying that these institutions can hold their own merit-based exam, or they can opt for a centralized test. It is up to their own will that how the admission will be taken. They have the autonomy, because of course they are private unaided. If you restrict their autonomy, it will go as a violation of Article 19(1)(g). Then with respect to the fees, with respect to fee structure, the court herein is saying that while profiteering is not allowed, we do not allow capitation fee, or we do not allow profiteering, institutions are free to set their fees subject to the condition that it does not amount to profiteering and capitation fees. Okay, you can make profits. We are not denying that, because you are ultimately doing a business, but it should not be such exorbitant. It should not be such capitation fee that it empties out the pocket of the payer, right? So it should not be in the nature of capitation fee, right? Then minority protections are reaffirmed in this case. The case is holding that minority institutions do have a right under Article 30, but minority institutions have a right to administer their own institutes under Article 30. But at the same time, it is a mandate on them that they should ensure transparency and fairness in the admission selection process as well. It cannot be made arbitrarily just because you have the power concentrated in just the management of the institute. So this was the decision in, pardon me, in PA Inamdar's case. This was basically also reinforcing what TMA Pai is holding and elaborating its scope to the state interference with respect to quota, with respect to seat, with respect to fee structure, etc. So this was the two cases which are discussed in the AOR leading cases list, the case number 18 and the case number 19. Now, one interesting turn that happens in this case is, now what is happening after the two judgments coming in? So we have seen a trend when we do a critical legal study of the discourse of Indian jurisprudence. It is often noticed that once Supreme Court gives some judgment which goes not so much in favor of the state, state coming in existence or state interference, amendment is the way that Parliament often exercise. So we saw it in Shah Banu Begum when the court is striking off iddat, striking off that maintenance will only be granted in iddat and not beyond in the Muslim law. The Parliament is coming up with the Muslim Marriage Dissolution Act, and it is providing that only the maintenance will be given till iddat. So basically, our Parliament has its own way of overruling what is being said in the, judgments, and they bring up an amendment, they pass a law, because of course the two are working in separation of power. Parliament do have a power to enact the laws. A similar thing is happening here, and also 2002 we have TMA Pai. Okay, 2004 we have PA Inamdar, and in 2005 we come up with the 93rd amendment, which inserts clause 5 in the Article 15. So Article 15 clause 4 was telling us that there will be reservation in the educational sectors for SCs, STs, and of course for socially and educationally backward class of citizens. But when I'm coming to the 93rd amendment, 93rd amendment is basically giving a counter attack to the decision that is held in PA Inamdar and TMA Pai Foundation, and it is saying that nothing in this article or 19(1)(g) shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward class of citizen, for scheduled caste or scheduled tribes, insofar as such special provision relate to their admission to the educational institutes, including private educational institutes, whether aided or unaided. So now an amendment is brought that that state may make laws. It will not prevent state to make any special provision for implementation of reservation or for providing quotas in educational institute, private educational institute we are talking of, whether they are aided, whether they are unaided. So this provision is basically giving power to the state to interfere in the management, and it will not be restricted because it is being passed by the Parliament. But however, it is coming with the restriction that this provision exception is Article 30 clause 1. So the only autonomous institute we have, the institute who will exercise its autonomy, will be minority unaided institution. So that is free to exercise the discretion, that is free to make use of its own power for the management, for the administration in its institution. But 15 clause 5 here by 93rd amendment is telling you, forget what is TMA Pai saying, forget what is PA Inamdar saying. If the amendment is brought to the effect, that nothing will stop, even Article 19(1)(g) will not stop the state from making any special provision with respect to providing quotas for advancement of SEBCs, SCs, and STs in educational institute which are private, whether they are aided or whether they are unaided. However, this amendment, of course, because it was an amendment, it was also challenged in the case of Ashok Kumar versus Union of India, and the amendment was of course upheld, because it is not that the parliament is unjustly overruling or manifest arbitrarily overruling what has been said in TMA Pai or PA Inamdar through this judgment, but the parliament is looking at the need. Okay, so there is a high class of population, high number of population which is belonging to the socially and educationally backward classes. We have the data in Mandal Commission, we have the data published in Indra Sani's judgment, which is bringing a quota for socially and educationally backward class of citizens. So court is also identifying that only government institutions cannot suffice to the needs of every citizen in India. So the court here is basically the parliament, pardon me, the parliament is also progressively looking at securing seats for the marginalized communities in also private aided and unaided institutions. And therefore, in Ashok Kumar Thakur, clause 5 is also being upheld because because parliament is saying we are not interfering with minority institutions. We are giving them their autonomy, because the purpose of minority institution is itself to will bring welfare to the students, to the children of their own community. But with other private unaided institutions, so that there is no discrimination. If a person belonging to marginalized community wants to study in a private institution, whether aided or unaided, he should not be denied any right. He should have a valid quota so that he can enter if the state makes a special law with respect to it. So this amendment, in my personal opinion, is also very progressive in nature. What TMA Pai and what PA Namdar are holding up, they are also very progressive in nature, right? So we sum up here with the discussion. Ashok Kumar Thakur versus Union of India is not, however, the part of the AOR examination. But since we are discussing Article 15 plus 5, coming in as a response to PA Namdar and TMA Pai Foundation, it is crucial here to also study what Ashok Kumar Thakur is saying, because ultimately 15 clause 5 in the 93rd amendment is being challenged therein. The amendment was upheld, 15 clause 5 was upheld, and it is adding in as a progressive provision for securing rights and no discrimination for any of the citizens of India. So this was it for the today's video. I know because we were covering two cases, it was a long video. Thank you for staying tuned till here. Keep watching, keep liking, keep sharing. Thank you, everyone. Have a great day.